Welcome back. In this video we're going to continue on with company worksheets. We've had a look at the director's duties in terms of the overview diagram, and now it's the director's duties worksheet. So I'll bring up the worksheet itself. Now in this worksheet we start with the legal theory and corporate veil. So you should make reference here in the Companies Act to sections 15 and 97. So you'll notice in section 97 it gives us the liability of shareholders, and it limits their liability to the amount of money they've agreed to pay for their shares. Other than that, a shareholder is not liable for an obligation only because they're a shareholder. They can, as we've discussed, be liable as a director potentially, and of course if they give guarantees directly to creditors, then of course they're liable under contract. Now, also note section 15, which is on incorporation. We have a certificate of incorporation issued, and that gives us the statement of separate legal personality. So if you combine those two together, you can talk about what it means to be a limited liability company from the perspective of a shareholder, and from a director we mean by the corporate veil, the ability to sue directors and shareholders. Do creditors have a right to sue the directors for the debts of the company in the same way they can sue the company if it doesn't pay them? Well, the company is an entity, so we sue the company. That leads us to the question of, if the company doesn't pay, can we sue the directors? And we've covered this. So you need to explain why it is that you can't go directly to the directors. In other words, you can't sue the directors automatically for the debts of the company. You have to go through a much longer process. When can creditors sue the directors? So summarize section 301, because in there we had that list of different types of breaches a director could be liable for. And note that includes things outside the Companies Act. It does include just common law negligence and breach of fiduciary duties and trust. Again, 126, we've covered this, so you should be able to summarize the three different types of shareholders. And then we turn to some examples, which is what we'll focus on right now. So, short question here. Bill and Ted are directors. They asked Ted to assist. Jed is retired but runs an adventure company and takes part in all meetings to discuss the venture and produce the business plan. So, when you're looking at this, you need to turn back to who is a director. So you'll turn to section 126. And ask the question, is this person acting in such a way that they would be a director of the company? So would they be a deemed director? Now, are they a named person, or are they acting in such a way that the named people are acting customarily under their instructions, or are they doing so because of some requirement, which would be a requirement in the Constitution, for example? Now, the answer is not straightforward, so you just need to set down what the rules are and then ask the question, well, what facts indicate Jed may be exceeding the role of simply an advisor and moving into the role of a director? The second one here, Druid supplies novelty products for shareholders. Two of them are not directors and take no active part in the company. So we have Bob and Betty as executive directors. So executive directors means directors that run the business on a day-to-day basis, whereas non-executive directors are on the board but have no day-to-day role in management. So if you work through here, we have Bob and Betty down as executive directors, so clearly they are directors. Are Ren and Stimpy directors? Now we know they're not directors as in terms of being mentioned in the company's office as directors and take no part in the company. So therefore we can assume that they are not. They are simply shareholders. And what about the manager to run the company on a day-to-day basis to tell them what's happening, any real problems? Well, again, you can consider section 126 and ask whether this accountant has overstepped the mark of being a manager and moved into being a director. The other thing you might want to consider here is their breach of duties in relation to the role of a director and having to make sure the company is managed under their supervision. Now, in this third section here, the Bean family manufacture musical instruments, and the company is started by Jelly Bean and her husband Jed, and they're elderly and spend most of the time at the veranda home, and the company is run by the children. So they resigned as directors, and Elmer and Jake become directors. However, they continue to help Elmer and Jake with the business and participate in all meetings and always ask their advice. So again, this is a section 126, 1B question, and whether the actual directors are accustomed or required to act under the direction of the other persons, and whether this would make them directors. Now, what we're going to look at now is to work through some of the sections which make up directors' duties. So the previous questions were really about who's a director. These questions are about what are the actual duties of directors. So we're staying with duty to act in good faith and best interests of the company, which simply says exactly what the title has: act in good faith, which is honestly, and in what they believe to be the best interests of the company. So that's things that will advance the company's interests rather than their own, and they must have a reasonable belief. Now, if we notice underneath here, we have this issue of subsidiary and wholly owned companies. Now, the problem we are looking at here is we have a company here, which we'll go back to a pencil. So we have company A, and we have company B. And we have, if we just look at directors, we'll ignore shareholders for now. We have A and B are the directors. And this company, A and B are the directors. Now, what if these companies have business? This could be a seller, and this could be the buyer of goods. So seller and buyer. So A and B are directors of company A, and in this role they have to act in the best interest of company A. They're also directors of company B, and in this role they have to act in the best interest of company B. So in company A they're saying let's get the most money we can. In company B they're saying let's pay the least amount we can. So the issue here is conflict of interest. There is a very clear conflict of interest going on with this. Now, that can't be resolved in that particular example. Those directors should not allow themselves to be in that position. But let's take this a slightly different scenario where we have company A, and it has the two directors A and B, and we have company B, and it has the same directors again. Now, what makes this different is it's a subsidiary. So it's 100% owned. So if we refer back to the original discussion of companies where we looked through the company's office, we found examples of what's a holding company or parent company and what is a subsidiary company. Now, it's quite common for a holding company, parent company, and a subsidiary to have the same directors. But again, the issue is conflict of interest, which can clearly arise. And this is covered in the Companies Act under this duty, where it says a director of a company that is a wholly owned subsidiary may act in a manner which he or she believes is to the best interest of the holding company, even though it is not in the best interest of the company. So that means A and B could vote when sitting as directors of B in the interests of the holding company A. However, there is a requirement. It must be if expressly permitted to do so by the constitution of the company. So that means the company B. So that means the constitution of B allows, that's terrible, allows the directors A and B to act in the best interests of the parent. All right, now I'm just going to leave it there with the notes and just make the point. It must be in this constitution because it's this company that is allowing these two people to vote in the interests of this company. Now, the people that make the constitution, of course, are the shareholders. And so all that really means is, since it's a wholly owned company, Company A, being the shareholder of Company B, has voted to amend or create a constitution of B that says directors, when sitting here, can act in the best interest of this company. Now, that is entirely acceptable, but it's something to be aware of when dealing with such companies. Now, if we go back to our spreadsheet, so you can see we're working through these sections, and subsection 1 requirements that we've been through. So here we have this example of a company on the direct board of two companies. One is the supplier, the other is the purchaser. What's the problem? And if they're not wholly owned subsidiaries, we have a real problem with that. So what this is asking you to do here is work through this and ask the question what it means and how does it affect the subsidiary company. What would you think if you were a shareholder of that subsidiary company and not a director of it, when you knew it had that provision in its constitution, or even a creditor of that company? Now, in addition to wholly owned subsidiaries, you'll notice if we go further through that section that we have a very similar rule for a subsidiary which is not wholly owned. So it still has to be a subsidiary, and if expressly permitted by the Constitution and with the prior agreement of the shareholders other than its holding company, act in a manner which is in the best interests of that other company. So the difference here is, instead of being a wholly owned subsidiary, that parent company, should use the bigger one there, that parent company is, let's say, just a 60% shareholder. So they have 60% of the shares. And we have another shareholder that has 40%. And that's what we'll call shareholder X. Now, all this means is we have a subsidiary where the parent company's directors are also the directors of the subsidiary companies, and we have another shareholder. So this conflict of interest is okay if it's in the constitution of B and the other shareholder agrees, right? So it requires the other shareholder agrees. So they have approved this conflict of interest. These things are hard to write with. So that other shareholders agreed, then it's not a problem. You can see from those examples, it only applies with wholly or partly owned subsidiaries and only with 100% consent of all shareholders. In the wholly owned subsidiary, that's just one shareholder, but where there's multiple shareholders, you get all of their consent to that. Now, section 133 takes us a little bit further. And just go over that one. So 133 just says a proper purpose. It's very, very short. A proper purpose is a purpose that is a company purpose, not a private conflicted purpose. So here, in your assignment, you might want to think about, well, what sort of things would not be a proper purpose? If I have a business that's a building company, should I be getting it to buy tyres for my four-wheel drive that I use to tow my boat? No, clearly not.